Good morning, good afternoon, good evening, depending on where you are. I speak to you from the west coast of the United States, where it is around 9 in the morning. I want to thank the Permanent Bureau for including me in this very exciting conference. And of course, I want to thank the audience for persevering to attend this conference for a fifth day, this being Friday. My general topic, of course, is the Hague Choice of Law Principles for International Commercial Contracts of 2015. But more specifically, I will talk about taking stock and planning ahead. I will talk about the road we have traveled and then what remains ahead. The Hague Principles have been a landmark development, and don't take my word for this. Take the word of people who really know what they're talking about, like these two very distinguished scholars from the United Kingdom, Professor Harris and Professor Dickinson. Indeed, the Hague Principles have been a success, both in terms of the quality of the drafting and in terms of their subsequent reception. And I say that as one of the initial skeptics about the principles. And let's not forget the people who really made this happen, the protagonists. Professor Gisberger, whom you have heard on the first day of the conference, who did a magnificent job in chairing both the working group and the special commission, and then Professor Marta Partegas, who coordinated the whole project very skillfully on behalf of the Permanent Bureau. The principles have been indeed a smashing success. And here are some examples of this success in terms of their subsequent reception. They have been incorporated into enacted legislation in Paraguay and Uruguay. They have also influenced proposed legislation in Chile, the Democratic Republic of Congo, Indonesia, Morocco, and Mozambique. They have also influenced some general principles or model laws or soft laws that have been drafted or are being drafted. The Asian Principles of Private International Law, the African Principles of Commercial Private International Law, and the Organization of American States Guide on the Law Applicable to International Commercial Contracts. The academic reception has also been generally favorable. I have counted so far 144 law review articles, all of which are generally favorable. And finally, last but not least, the arbitration community is generally favorably disposed towards the principles. So let's give the Permanent Bureau a pat on the back for this success. Indeed, a smashing success, as I said earlier, and that's to be sure. But with all due respect, party autonomy, which is what these principles are about, was the low-hanging fruit, because it is relatively non-controversial. Nobody is against this idea of allowing parties to choose the applicable law, especially in commercial contracts. So it's like, as we say in the United States, it's like motherhood and apple pie. Everybody likes that. And also because drafting a document about party autonomy is relatively easy in the sense that there are a lot of available templates in existing legislation and so on. It was a good choice to begin this contracts project with party autonomy. As Sir Roy Good said, one should avoid excessive ambition. It is better to have a limited target that is achievable than a grand design that is not. So the 2015 principles have followed that advice, and we met that goal. But now comes the difficult part, but one which is well worth it. Now we should be ambitious. To quote Jack Kennedy, we choose to do things not because they are easy, but because they are hard. So we should not shy away from the difficult task ahead. The Hague Conference must take the lead in creating, I underscore that, an international consensus on the remaining part of the contracts project. Technically, the mandate of the Council of General Affairs and Policy is already broad enough to cover this new phase, because the Council noted back then that there was support for a comprehensive draft instrument which would include rules applicable in the absence of choice of law by the parties, but priority should be given to the development of rules in cases where the parties have made that choice. And that's what we did, and that was the right priority. But now we should move to the next phase. And this is the road ahead. So, in my humble opinion, this is my recommendation: to establish a new working group to complete the contracts project by drafting a new instrument, which should provide for, number one, contracts, commercial and non-commercial, that do not contain an effective choice of law clause, and non-commercial contracts that contain a choice of law clause. These are the two parts. In addition, the new instrument should update the 2015 principles in order to address the new needs of the digital and finance industries, clarify the line between commercial and non-commercial contracts, and provide for choice of law agreements for non-contractual issues. I will elaborate on all of these points. Now, one preliminary question is whether the new document should be in the form of a convention or a soft law instrument. There are arguments pro and con, but in my view, having worked on both a convention and soft laws, this should not be a closed question. We should proceed with a soft instrument for a variety of reasons, including the fact that we already have a successful soft law instrument, the 2015 principles, and we should conceive of the new instrument as complementary of or parallel to the 2015 instrument. The role of the new instrument is to gradually create approximation, harmonization, and eventually consensus on this subject. We should not expect immediate conformity. We should take a long-term view. The convention, as we all know, is more political, and countries hesitate to ratify it. A soft law instrument appears more innocuous, so to speak. Now, what is done and what is left? So if you think of the distinction of conduct into commercial and non-commercial, which is adopted by the Hague principles, these are the four squares that comprise this whole subject. And in the green square, you have commercial contracts which contain a choice of law clause, and this is what the 2015 principles have provided for. So what remains is the other three squares, and the new instrument should provide for all three of these squares. In summary, how should we go about? Well, let's take first commercial and non-commercial contracts that do not contain a choice of law clause. Here, in principle, we can adopt the same general rules for both categories. So this will be part one of the new instrument. And then part two of the new instrument should deal with non-commercial contracts which contain a choice of law clause. And here, generally speaking, we could extend the 2015 principles, but as I'll explain later, omit Article 3 and protect weak parties. Finally, the third part of the new instrument should update, or at least the project should update, we should update the 2015 principles. So let's focus on the two main parts of the new instrument. First, as I said earlier, we'll take commercial and non-commercial contracts that do not contain a choice of law clause. And there we'll begin with the relevant provisions of Rome 1 as a starting model, but also be open to making adjustments, updates, and improvements to those provisions. And then we'll take non-commercial contracts in which the parties have chosen the applicable law, and there we can duplicate the 2015 principles, but omit Article 3 on non-state norms and provide protections for consumers, employees, and other weak parties. And finally, update the 2015 principles to address the needs of the digital and finance industries and provide for choice of law agreements for non-contractual issues. Let's take the first part that is the one that will provide for commercial and non-commercial contracts which do not contain a choice of law clause. First of all, do we need such an instrument? Well, we have the answer. The Permanent Bureau conducted a survey, and 68% of respondents answered with an emphatic yes. And and so did all the previous speakers in this conference. And the new instrument should cover both commercial and non-commercial contracts. We should not neglect the second category. Now, of course, the working group can draw from a variety of sources in deciding which general approach or combination of approaches to follow in drafting this part of the new instrument. Without prejudging the group's decision, I would suggest that Rome 1 should be at the top of their list. Rome 1 is a relatively successful instrument. Plus, it has been emulated by several countries outside the European Union, along with its predecessor, the Rome Convention. Therefore, it would be prudent to begin with the relevant provisions of Rome 1 as a starting model. But of course, the group should also be open to making adjustments, updates, and improvements. It will also need to devise solutions for new types of contracts, such as electronic or smart contracts, which were not common when Rome 1 was adopted. Now, the second part of the instrument, which will deal with non-commercial contracts in which the parties have chosen the applicable law, have agreed on the applicable law. In other words, we're dealing with this quarter here. And as I said earlier, the initial thought should be to extend the 2015 principles, essentially duplicate them, but omit Article 3 and protect weak parties. Now, why omit Article 3? Admittedly, this is a matter on which there are good arguments on both sides. It is an important topic that calls for an in-depth, dispassionate discussion. But For what it may be worth, my personal and perhaps biased opinion is that the arguments for allowing parties in non-commercial contracts to opt for non-state norms are far weaker than in commercial contracts, which is what the 2015 principles cover. The risks really far outweigh the benefits, if any, but that's again my personal view. I could well be wrong, as I have been in the past. But for sure, in drafting this new instrument, we should make sure to protect consumers and employees. Now, as you would recall, the 2015 principles protect consumers and employees by excluding them from the scope of the principles, by excluding consumer and employment contract. Excuse me. Now, the new instrument must provide for these contracts and should carry forward the idea of protecting consumers and employees. In principle, there is no good reason to prohibit choice of law clauses in these contracts, but the new instrument should impose express limitations on choice of law clauses so as to protect consumers and employees. And here again, the protections provided in Rome I are a good starting point and perhaps a good point with which to end. What about other presumptively weak parties in non-commercial contracts again? Well, the new instrument should also protect those other weak parties. That is, parties that fall outside the scope of the 2015 principles, namely contracts in which one party is not acting in the exercise of its trade or profession, non-commercial contracts, in other words, using here the definition of the 2015 principles. For example, contracts for the carriage of passengers, or say a patient's contract for medical services, or a homeowner's contract with a building contractor for some house improvements or building the whole house, or with an architect. These are all non-commercial contracts, in my view, and the new instrument should provide for them, perhaps having separate rules for each category of contracts, if that's possible. If not, then we should make sure that the choice of law clause in this contract should be subject to some public policy limitations. And here is an important point that I don't have time to elaborate on. That should be the public policy of the objectively applicable law, the lex causa, in other words, not the lex fori as such. I have written a lot on this principle. It's one of the differences between American and European law. Just I planned this thought. What about other presumptively weak parties in commercial contracts, which are the subject of the Hague principles? Well, for example, franchise contracts or licensing contracts fall within the scope of the 2015 principles because each party, including the licensee or the franchisee, is acting within the scope of its trade or profession. So these contracts clearly fall within the scope of the principles, and it's too late to do anything about protecting the weak parties. This may be one of the deficiencies of the 2015 principles. But there are also some other contracts about which perhaps we can do something. For example, the comments to the 2015 principles state that insurance contracts and agency contracts also fall within the scope of these principles. Well, perhaps that is debatable or should be debatable. And the drafting of the new instrument will be an opportunity to re-examine whether all insurance contracts or all agency contracts are indeed commercial contracts. What about a homeowner's insurance policy? Perhaps the homeowner should be treated as a consumer in that case, in which case this contract will not fall within the 2015 principles, but it should be the subject of the new instrument. So the new instrument should address these contracts and also provide appropriate protection for insurers and non-professional agents. Finally, we should consider updating the 2015 principles by, among other things, addressing the new needs of the digital and finance industries, more clearly clarifying the line between commercial and non-commercial contracts, such as the examples I just mentioned, insurance contracts, agency contracts, and provide for choice of law agreements for non-contractual issues. That's an important topic that causes a lot of litigation in several countries. We have an opportunity to take a position on whether choice of law by the parties should be allowed for non-commercial issues, and if so, subject to what kind of safeguards and limitations. So in conclusion, the adoption of the 2015 CAIC principles was a landmark development and has been a smashing success. However, the CAIC conference should not rest on its well-earned laurels. It should take the lead in laying the foundations for an international consensus on the remaining parts of the contracts project. These are my 2 cents. Thank you for your patience.